Ladies and gentlemen, welcome to Corporations Committee. Just by way of some housekeeping, if you're here we have 4 bills up today, and if you're here for the last 2, you've got some time, you can go get some coffee or something. So we'll actually start the hearing as soon as we get another member to have a quorum. But Representative Larson, are you going to start us off on this bill? Why don't you come up and get ready, and can we get you some coffee or anything? All right, thanks. See, I believe Senator Dockstader had another meeting presenting a bill. I'll see about Boner. It started out skinny, but the House fattened it up. You know, it's like that 69.
You had a few amendments on this.
Yeah, you did.
Yeah, a couple.
Okay. All right, again, welcome everybody. Let's go ahead and get started. The first bill for our consideration is House Bill 192, Public Utilities Wildfire Mitigation and Liability Limits. I think the committee will recall that we flirted with this concept in the interim a little bit. We believe it also ended up going to, was it minerals? I'm not sure. And then, so it comes back as an individual bill here, and Representative Larson's here to tell us about it. Welcome.
Good morning, Mr. Chairman and members of the Corporations Committee. My name is JT Larson. I serve for House District 17, and I'll just go ahead and go through the bill and kind of give you a little bit of background. So you are correct. The Minerals Committee did take this up as an interim topic, and we even had an additional meeting in the November, December timeframe. And the committee was uncomfortable with the amount of amendments to the interim bill that were coming in, and we just decided not to move the bill forward. The bill that you have in front of you has amendments from the working group that were incorporated. Now, I will say the working group that was put together had a lot of representation from various industries, from public utilities to landowners. And so there was a lot of work put into this, but there were no representatives or senators that sat on that working group to kind of work through those amendments with them and really understand what they brought to us at the last meeting. So the committee felt uncomfortable, and that's why it's come to you as a personal bill rather than a committee bill, because after further discussions after that meeting, we felt that it was still very important to get this piece of legislation through and incorporate those amendments. So this is all the amendments incorporated, plus the House had a couple of amendments, and I'll go through those just really quick before I go through the bill.
Okay.
We were just adding on page 6 after line 21. This was a request by our firefighters to make sure that there's input from the Wyoming State Forestry Division of the Office of State Lands and Investments, and then an association representing Wyoming rural firefighters and any other appropriate federal, state, or local fire entity. Not sure why that wasn't there in the bill in the first place. It was just not thought of, but it's definitely a friendly amendment that was added to the bill and enhances it, I think, really well.
Okay, and Representative, you're holding the original copy there. We've got the engrossed version.
Yes.
So that
Yeah.
what you're talking about tracks in on the very next page. But
Yeah.
keep going.
Yep. Sorry about that, Mr. Chairman.
No worries.
And then on the original introduced version, page 8 after line 21, it's a paragraph. Insert and renumber as necessary. B, an electric utility and a landowner with an alleged wildfire related claim shall negotiate in good faith before any landowner files a civil action against the electric utility. During negotiations, an electric utility shall respond to a landowner not later than 90 days after receipt of the landowner's submission of itemized damages. This amendment specifically was needed to make some people comfortable enough on the committee to vote for the bill. It was, they were worried that the utility was just gonna kind of back off and not try to work with landowners, and that's not the case, and I'm not saying that would be the case, but having the language in there made the committee feel more comfortable, and so that's why they added it, and I think it helped get the bill across the finish line on the House side, so.
Okay.
That is that amendment, and then we also added, per request of the PSC, the original to the original copy, page 7, line 9. It says, and I can track that in, so it makes a little more sense here. Get to that page. So this is dealing with the commission approval, and so it says, unless the commission deems it is necessary to continue the implementation of the wildfire mitigation plan for a longer period of time, and the commission has entered an order confirming the continuance and stating the facts making the continuance necessary. So it's just trying to make it clear that the PSC can continue with that plan and not have to redo the whole process. I think that's a reasonable cleanup for their office, and that was also a friendly amendment that we added. So with that, I'll kind of walk you through the bill, and so page 2, you have definitions that are used throughout the bill.
You've got, still got the white bill, right? That's
Yes, this is the engrossed version.
Oh, okay.
Yep.
So it is engrossed. Okay,
Yep,
we're
yep.
with you then.
Yep.
Thank you.
Yep. So page 2, you got definitions. Page 3, this is the 37-3-402 just says that nothing in this article shall be construed to limit the commission's authority to regulate utilities or promulgate rules under the provisions of this title. Just wanted to make it clear that PSC can still do the job it's doing today, and it's not supposed to impair anything they're already doing. Now, as we move on to the second half of page 3 of the engrossed version, we start laying out the contents of these wildfire mitigation plans. And so you can see the first part, or the first Romanette, deals with heightened risk areas in the utilities territory or rights of way. The second Romanette deals with procedures that will be used to inspect and operate the infrastructure. Romanette 3 deals with, well, actually, let's see here. May have got ahead of myself. It deals with a description of the procedures and standards that electric utility will be used to perform vegetation management. 4, it works to reduce the risk of any facilities of creating a fire. 5 deals with coordination with other utilities, and also how their policies have changed in the immediately preceding 5 years. And sorry, that was 6 for the coordination of other utilities. And then 7, a description of the procedures and considerations for de-energizing power lines and disabling reclosers to mitigate potential fires. Going on to the next page, it kind of breaks down the de-energization steps and qualifications for that. Going on to page 6, Romanette 8, a description of the procedures the electric utility intends to use to restore its electrical system in the event of a wildfire. 9, for electric utilities whose rates are regulated by the commission, a description of the estimated incremental costs and potential associated rate impacts for the implementation of the wildfire mitigation plan, including system improvements and upgrades. So it's going to be your Rocky Mountain Power and others like them. Romanet 10, a description of community outreach and public awareness. I think that's very important. Number 11, a description of potential participation with emergency coordinators if applicable. And then that's where we added that amendment for input from the Wyoming State Forestry as well. Then we move into the next part of the.
Hold on a sec, Representative. Senator Boner.
Thank you, Mr. Chairman. Just a question, it seems like those are all pretty important concepts. That's what the whole bill revolves around. Just, I guess I'll share a story of something that happened in Converse County where we had a relatively old power line that was being I guess utilized perhaps beyond its capacity because of all the oil field activity. And this thing was, there's so many splices in it, it just simply wasn't, adequate to the task that it was being asked for. And I'm glad that the utility in question eventually got around to replacing it, but not before it started about 2 or 3 fires. And so I didn't see anything in here that contemplates maintaining the infrastructure to a safe level. Like, is there anything that contemplates actual quality of the infrastructure, making sure that it's not subpar? It seems common sense, but I just don't see it in there in that long list of elements of the plan. So they can, do all this, fuels mitigation. They could, talk to the state forester all they want, but at the end of the day, I don't see anything that contemplates them actually maintaining the infrastructure to an adequate level. But maybe I'm missing something. Maybe you can point out to me.
Thank you, Senator. Representative?
Thank you, Mr. Chairman. And this may also be something that Sean Taylor with the working group can answer, but I think that Romanet 4 may address that. And if I'm reading it wrong, let me know. But it says a description of proposed modifications, replacements and upgrades to facilities and preventative programs the electrical utility will implement to reduce the risk of its electrical facilities initiating a wildfire. I think that's covered under that, and that would be like their power lines as well. And so I think it's covered, but
Right.
I don't know if
We can discuss that. We bet we'll get them up.
Yeah, and perhaps maybe add routine maintenance in there, because it seems like, it could be a little bit clearer, but yeah, we can think about that. Thank you.
absolutely.
Thank you, Senator. Thank you, Representative. Keep going.
All right, thanks, Mr. Chairman. So now we're getting into the part of the bill where we're dealing with the commission approval. And it basically says that it lays out how the commission will approve the plan. And so upon receiving an application for approval of a wildfire mitigation plan, the commission shall, not later than 120 days after receipt, unless the commission deems it necessary to continue the implementation of the mitigation plan for a longer period of time, and the commission has entered an order confirming the continuance and stating the facts, making the continuance necessary. That's where we added that amendment. Approve the plan if the plan is reasonable in the public interest and appropriately balances the costs of implementing the plan with the risks of potential wildfire. For electric utilities whose rates are regulated by the commission, approval of a wildfire mitigation plan shall not automatically confer to the electric utility the right to recover the costs associated with the wildfire mitigation plan. An electric utility whose rates are regulated by the commission may seek the commission, and the commission may authorize cost recovery for the costs associated with implementing a wildfire mitigation plan. Now, I will go down into that a little bit more. A lot of the wildfire utilities or the electric utilities are already doing wildfire plans internally. The PSC will be able to set a standard and kind of go back and forth with them for improvement of that plan. But this is something they generally are already doing, so I don't expect, if there are rate impacts, I don't expect them to amount to really a substantive amount to the ratepayers. And I always like to say, I would much rather pay $1 extra a month on my bill than $20 extra a month if there was a wildfire settlement that the utility had to pay. So just an additional thought there, and that's just there's no math behind that. It's just
Right.
an analogy I like to use. So moving on, each electric utility shall submit subsequent or updated plans to the commission not later than every 5th year after the electric utility last submitted a plan to the commission. And then it goes into not later than June 1st in the following any year in which the commission approves a wildfire mitigation plan under this section. An electric utility shall file an annual report. So it's having that routine check back with the PSC, making sure that they are following their plan and doing what's in the best interest of the ratepayers for these plants. Now we get into recovery of costs. And so that is going to be on page 9. Except as otherwise provided in this section, there shall be a presumption, and this is for if there were a liability. And so the approved wildfire mitigation plan is a reasonable and prudent preparation for and mitigation of the wildfire risk. Now, there's later on in the bill, there's gonna be ways that people can get around that. So it's a rebuttable presumption, as they call it in law. So we'll get into that, but go to subparagraph B, the electric utility and a landowner with alleged wildfire related claims shall negotiate in good faith. That's that amendment that we added in there to make the bill a little more comfortable. Subparagraph C, this is where it lays out where a plaintiff may recover economic loss. So a plaintiff may recover economic loss from an electric utility as a result of a wildfire only if the plaintiff shows one or more of the following by a preponderance of the evidence. And this is something that they will argue in court in front of a judge, and the judge will make that determination. So 1, the electric utility failed to substantially comply with an approved wildfire mitigation plan, and that failure was the actual and proximate cause of the damages to the plaintiff. For the purposes of this paragraph, an electric utility shall be deemed to have substantially complied with the wildfire mitigation plan if the electric utility attempted in good faith to comply with the plan but was denied or unreasonably delayed access to a right-of-way after the electric utility requested access to the right-of-way to perform vegetation management or fire mitigation work in accordance with the plan. And then number 2, the electric utility acted with malice or criminal intent, and the electric utility's action was the actual and proximate cause of the damages to the plaintiff. So people get worried that we're giving public utilities or utilities in general complete immunity, and that's just not the case. There is a way that they can, the plaintiff can recover economic loss due to neglect of the utility. So, and they break down the following shall apply in any civil action that any plaintiff brings in against, or wait, sorry. Yes, so against an electric utility damages caused by a wildfire. An action against an electric utility for damages caused by a wildfire shall not be brought later than 4 years after the date of the ignition of the wildfire. This is something that is standard in other parts of law, 4-year, time frame, and that's something that the landowners of the working group felt was reasonable and comfortable for them. And then 2, a plaintiff may recover economic losses. 3, no plaintiff shall recover non-economic damages unless the plaintiff's claim is based on the injury or death of any person in a wildfire. And then 4, nothing in this section shall be construed to limit any defenses that an electric utility may be entitled to raise in a civil action for damages caused by a wildfire. Section 2, nothing in this act shall be construed to impair, alter, or preempt any terms or agreements in original grants of easements made before July 1st, 2025. In Section 3, the Public Service Commission may promulgate rules. Section 4 are our split effective dates. And with that, I will stand for questions, but I'll just say, as we go through, as the committee goes through the process, just keep in mind that there was a lot of hours put behind this from the working group, and there may be amendments brought forward, and I would just, make sure you ask the questions to the working group members as far as whether those amendments may or may not be friendly to the bill. I'm kind of letting this bill take its own course as it was a minerals interim committee bill. But with that, I'll stand for any questions, and if not, I'm sure Sean Taylor probably wants to get up here and talk about it. So,
Wow, you've identified the public enemy number one as far as sponsoring this bill. Now we know. Committee, any questions for the good representative? Any questions? I think Representative will go to the Public Service Commission next, if that's all right with you. And, now it's our bill.
yeah, absolutely.
So
Go ahead.
good to see you, and thanks, you did a great job.
Thanks.
Stay close. Would you guys like to go next to Public Service? You want to wait, or? Okay. Hey, you guys, that's just a joke. Everybody all right? I understand. So, Mr. Taylor, sounds like you headed up this working group, so come to the table. Be joined if you have any friends. I don't know if you do. Welcome, Mr. Taylor. It's like you do have friends.
Yeah, thank you, Mr. Chairman. Members of the committee, my name is Sean Taylor, Executive Director of the Wyoming Rural Electric Association, here on behalf of the 14 distribution cooperatives and the 4 generation and transmission cooperatives that provide power to rural Wyoming.
Come on, you guys.
Obviously here in support of the bill, and I wanted to give you a little bit of background. Representative Larson did a great job of explaining kind of how we got here and walking through the bill and the work that's gone into it. But as you mentioned, Mr. Chairman, it started in joint minerals interim last year. There was at one of their earliest meetings, some representatives from the state of Utah zoomed in and talked about some legislation that they had recently passed with regards to wildfire and liability limits. About that same time, the state of Utah was considering or going through the motions of putting together a similar bill, or at least a bill to deal with the same issue. And at the meeting in Casper at the beginning of the summer, the instructions from the chairman, Senator Dockstader, unfortunately isn't here right now, but and Representative Burkhart were to, they heard testimony from a lot of the stakeholders, as was mentioned by Representative Larson, and that the stakeholders involved with utilities, landowners, industrial customers, representatives from insurance companies, Public Service Commission, Office of Consumer Advocate, and Senator Dockstader and Representative Burkhart may not have been part of the stakeholders group, but we kept them in the loop on the number of, we had a number of Zoom meetings, email exchanges to try and take the best of those 2 bills from Utah and Idaho and make what was best for Wyoming. And a lot of work has already been said, has gone into that. We continue to work with folks even outside of that initial stakeholders group, even up until yesterday, to try and find a common ground where there were concerns. The amendments that Representative Larson mentioned that were offered in the House made the bill, I think, a stronger bill and brought even more folks kind of into the fold. And there's some amendments that will be offered today, again, that we've worked with interested parties, and we're okay with those because I think it addresses some concerns that may have been brought up regardless. And so I guess I would cut it short because I think the representative did a good job. I would just want to give you a little bit of background and who all was involved in the stakeholder group. I don't want to speak for them. They're all in the room today, so I'll let them speak for themselves. But from the
I kind of hope they all don't have to.
from the cooperatives perspective, this is a Wyoming problem, and we brought together Wyoming people to get a really good bill before you today. Thank you, Mr. Chairman. Happy
Thank you,
to answer
Mr.
any
Taylor. Questions for Mr. Taylor? Okay, who's next? Hello,
Oh,
go ahead, Mr. Taylor.
yes, I did want to address Senator Boner's questions. I think they're addressed on page 3 and 4.
You got the engrossed bill?
Engrossed bill, yes, sir.
Okay.
Under paragraph Romanet 2, a description of the procedure, standards, and schedules that the electric utility will use to inspect and operate its transmission and distribution infrastructure. I hope that would catch your concerns, as well as in paragraph 4. This is a description of proposed modifications, replacements, and upgrades to facilities and preventative programs that the electric utility will implement to reduce the risk of its electric facilities initiating a wildfire. That also may come under asset management with the various utilities. So I think between those two paragraphs, I hope we address the concerns that Senator Boner had. But if we need more clear language, we're happy to work with you.
Thank you, Mr. Taylor. I just want to mention that Senator Dockstader is presenting a bill, and he will be back. And actually, so I recall, Senator Steinmetz has a bill up too.
Yeah.
It's past crossover, so all the bills that people are caring about are in the hands of people like Representative Larson. Anyway, okay. Let's go ahead, ma'am, you're next.
Thank you, Mandy Good. I'm here with WREA. The one thing I'd like to point out, in addition to what Mr. Taylor just covered, is we've heard a couple concerns about whether this is immunity, and I want to echo what Representative Larson said about the limitations on it. I'd also like to point out on page 9, line 18, you're in subparagraph C there. It says a plaintiff may recover economic loss from an electric utility as a result of a wildfire if these things happen. And then on page 10, we also have at line 17, where it's limited to damages caused by a wildfire. So the following shall apply in any civil action that any plaintiff brings against an electric utility for damages caused by wildfire. This bill is limited to wildfire situations. There's no liability limitation if an electric utility had some other issue that gave someone a cause of action against them. So there's not some blanket immunity created by this bill. And I wanted to make sure that was out and up front.
So, Ms. Good, right?
Yes.
Are you saying that there could be a wildfire, but a plaintiff could show that the damage, even though there was a wildfire that contributed to the event, plaintiff could show that the damage was due to something else that the utility did? Is that what
No.
you're saying?
Chairman Case,
Go ahead.
what I'm getting at is, let's say somebody from the utility, I mean, God forbid they'd ever do this, but let's say in the rainy season, they went out and mud bogged in a cornfield and destroyed a field.
I see.
This doesn't touch on something like that. It's unrelated to wildfire. They can still go after a utility in that situation. So this is only a wildfire bill.
But it's anything coming out of a wildfire, right?
In a situation where an electric utility has followed its mitigation plan, there's no malice and there's no criminal intent, there is liability protection for wildfire-related issues, yes.
Okay, thank you, Ms. Good. Did you have anything else?
That's all I have unless there are any questions.
Questions for Ms. Good? Thank you both. Who's next? Let's fill out the chairs. If there's a third person that's with your group, if there's just two, we'll take just two. Yes, sir, go ahead.
Thank you, Mr. Chairman, members of the committee. Austin Rodemaker with Tri-State Generation and Transmission Association. We are an electric G&T cooperative providing wholesale power to 8 distributive cooperatives in Wyoming with 41 member owners across 4 states. We are here in support of House Bill 192. We handed out a one-page document earlier that we created in cooperation with the Wyoming Rural Electrical Association discussing why we support House Bill 192. And with that today, I also have Mr. Hartenstein. He is our wildfire program manager at Tri-State. And Mr. Chairman, if it's okay with you, I'm going to hand it over to him.
Okay, any questions for Mr. Rodemaker?
That's correct.
Any questions? Thank you. Let's hand it off.
Mr. Chairman.
Go ahead.
Good morning, Mr. Chairman, members of the committee. Thank you very much for hearing me today. My name is Curtis Hartenstein. As Mr. Rodemaker said, I am the Wildfire Mitigation Program Manager for Tri-State Generation and Transmission. I've been practicing wildfire mitigation, fuels modeling, forest health, and similar wildfire recovery for nearly 20 years, the past year and a half with Tri-State. I'm also a volunteer wildland firefighter with my local fire protection district. So this issue hits pretty close to home in a number of ways for me. I'd just like to make a couple of points in that, the ever-increasing cost of wildfire insurance coupled with reduced coverage limits are really impacting Tri-State. We've seen increases of coverage from $5 million to $7.5 million while our damage protection was decreased by half in that period. And moreover, that kind of insurance is becoming more increasingly difficult to manage. And of course, being a cooperative, working with member co-ops, we're all nonprofits, these costs are becoming pretty difficult to manage. And the real challenge in managing these costs is the balance that we face in fighting this issue that we have in front of us with wildfire mitigation. To do the kinds of work that we do for vegetation management, system hardening, asset protection, risk modeling, these do require funds. And it's really difficult position for a utility to be in, to spend hundreds of thousands, if not millions of dollars in best management practices, to be aware of one's risk and mitigate that risk while still being potentially liable for millions of dollars in subsequent damages. So I'm here today to answer any questions that you may have on the bill with respect to the subject matter, and happy to do so at the pleasure of the chairman. Thank you very much.
Any questions for Mr. Hartenstein? Go ahead, Senator Landon.
Mr. Chairman, thank you. And just to go back to, can you repeat, you mentioned that Tri-State, for example, carries some liability types of insurances, and I think you said that it went up by about an awful lot, half again. Can you restate that for me?
Mr. Hartenstein.
Mr. Chairman. Senator Landon, so we saw an increase of $2.5 million this past year. So we went from $5 million to $7.5 million in premiums, while our coverage was decreased in half in this past year.
So
Go ahead.
So is it your experience throughout systems that you provide power for, are these rural co-ops, most of them carry this kind of liability insurance, I'm sure. Similar stories coming back to you on that front?
Mr. Hartenstein.
Mr. Chairman.
Mr. Rodmaker.
Mr. Chairman, thank you. Senator Landon, yes, we're seeing that a similar concept across not just our G&T that serves 41 member owners, but also the member owners that own us, that they're having the similar issues where insurance costs are rising or almost not available in some instances, where they're now resorting to self-insurance, which obviously in a cooperative situation is going to drastically increase costs for the members.
Yeah, thank you.
Anybody else? Thank you, gentlemen. Who else would like to testify on this bill? There you go. Can we get people to come up and fill out the chairs? That would be really helpful because it just takes less time to change over. Mr. McLaren, you just took your badge off.
Well,
Mr.
Chairman,
McLaren.
I'm normally here with WHAM, but this morning I'm here to speak to you as a director of Lower Valley Energy, with whom I serve. Senator Dockstead
one
is our
right here.
chairman.
Yeah.
We support this bill very strongly. It's a really, really important issue to Lower Valley. And just to give you a little perspective, our insurance costs from 2022 to 2024 went from about $250,000 to $400,000. We are on an annual basis spending in 2024, we'll spend 800 grand on wildfire mitigation. That's, vegetation management, that's burying power lines. And then on capital expenses related to wildfire mitigation, vegetation management, grid hardening, we're going to spend $5.1 million in 2024. So there's been some talk about this is going to drive up the cost of rates. What I would submit to you is we're doing this now, and so these costs are in our rate structure. This is a very important issue, and I hope you can pass this bill on to the body. Be happy to answer any questions, sir.
Thank you very much. Any questions for Mr. McLaren? That's your chance, fellow. You could just,
Well, no, I won't. But I will also publicly declare I am on the board of directors for Lower Valley.
Thank
But
you.
I will still, Mr. Chairman, be voting on this because I represent a larger audience.
understand completely. Thank you very much. All right, Mr. Detai.
Good morning, Chairman Case, members of the committee. Travis Detai with the Mining Association. And my membership is in support of the bill. And I would just offer a couple of comments. My membership knows the difficulties that it takes to get insurance and costs of insurance right now. And we believe if this can help the utilities to go out and get the insurance they need, we would be supportive of that. And I think, in the general larger context of, we've considered rate increases as well. And, if anybody dislikes rate increases, it's my industry. But I think the old adage of an ounce of prevention is worth a pound of cure. And getting into that situation down the line where if something catastrophic were to happen, then your rates really go up. So I think in that respect, I think we would, whatever, and I'm not even sure how high they would go up. I mean, I think that utilities are doing a lot of the stuff that they need to do anyways as far as mitigation, but I think that we would certainly be able to absorb rates in this respect in order to, again, if something catastrophic were to happen, and we found ourselves in a situation like California or Hawaii, then we're in real trouble because then the rates really go up. And then the backside of that is you want a little protection, I think, for our utilities so they don't get the pantsuit off of them in like what we're seeing out west as well. Because the ultimate interest for my membership is we want to keep these utilities healthy and keep them burning Wyoming coal. And so with that, Mr. Question, I'll stand subject to your questions.
Thank you very much. Any questions for Mr. Detail? Thanks a lot, Mr. Detail. Mr. Bush?
Mr. Chairman, David Bush with Black Hills Energy. I'll try to be as quick as possible. In support of the bill, part of the working group that went through this throughout the year, and just it was remarkable to watch, and I think it's a good test. That's not the word I'm looking for, and I'm sorry. Testimony. There you go. Thank you.
There you go.
To how the process should work, to bring all those groups together. We all gave a little bit. We all worked together as best as we could to come to a good compromise on a bill. And it did take a while, and it took a lot of meetings, as Mr. Taylor talked about. So, the old adage that Senator Enzi used, 80% is generally where we can get to. Everybody can kind of get to that 80% on a bill. It's that last 20% that people seem to get caught up on, and that'll doom legislation. This is good legislation. It's 80% of what we all want, but we're good with that. So please pass the bill.
Okay, any questions for Mr. Bush? Thanks, Mr. Bush.
Thank you.
Ms. Levin? We got two empty chairs up here. Come on.
Good morning, Mr. Chairman, members of the committee. I'm Jody Levin. I'm here on behalf of Charter Communications. Mr. Chairman, I have an amendment for the committee to consider. I don't know if you want me to address that now or if you want to.
It'd save you coming up again, so.
Perfect. Mr. Chairman, Charter's concerns are limited to page 11, section 2 of the bill. So section 2 addresses that nothing in the act shall be construed to impair, alter, or preempt any terms of easements made before July 1, 2025. Charter's concern with this is that it is specific only to easements and not agreements. So my client and others in the communications industry will have agreements with utilities to utilize their poles. We call those pole attachment agreements for communications infrastructure. So what we would like the committee to consider is that after easements, you would strike the remainder of that line and you would insert or the terms in any other agreements between electric utilities and third parties. I did provide that amendment to staff and it has been filed with LSO. And I hope it's been circulated to everyone. I tried to get that to anyone that I knew was working on this issue so that they understood Charter's concern. This issue unfortunately comes to you because of activities that have happened in other states where it has become necessary to clarify that something like a wildfire mitigation plan can't be used to have a utility not honor these agreements.
Okay, any questions for Ms. Levin? Senator Dockstader?
Thank you. Mr. Chairman, Ms. Levin, I'm just a little concerned, any other agreements, that's a very broad approach.
I've got the same thing.
I would be cautious of the amendment.
So, Ms. Levin, I'll just tag on. You said you're worried about pole attachments and those kind of use of utility facilities, which I understand completely, but this says any other agreement, so help us with that.
Mr. Chairman, the issue that my client has raised, the example that they gave me is specific to pole attachment agreements, but that might not be the only agreement that they have with the utility. And what is happening, of course, in other states as you see litigation is who do you start to point a finger to and who do you try to recover damages from? So the infrastructure that's being located on these facilities isn't going to start a fire. But when you get into litigation, telecommunication companies and my client have been drug into lawsuits that unfortunately have had to go to state Supreme Courts to get addressed. So really, it's just trying to say that if, and if there's a way to try to limit this down, I don't know how to quite finesse that. I think we all call them pole attachment agreements. I don't know if that's actually the technical term that you would use in those instances. Maybe it is. I'm not an attorney, Mr. Chairman, so I don't negotiate these types of agreements. But the concern, of course, is that you're really only talking about easements in Section 2, and there are other agreements that a utility could try to say that they are now no longer obligated to honor because it's silent as to what happens to those other agreements.
So, Ms. Levin, let me just reach out here. So I think in the federal telecom law, there's definitely a definition of pole attachments and other facilities, and they contemplate, like conduit and all sorts of things. But I was wondering, if I throw this back at you, or the term in any other agreements between electric utilities and third parties for the shared use of facilities, or something like that. We'll take it up later, but I'm just throwing that at you a little bit.
Mr. Chairman, I appreciate that consideration.
Okay. Any more questions for Ms. Levin? Okay.
Thank you, Mr. Chairman.
Mr. Schultz or Mr. Carter? Who's going to go first? Mr. Carter.
I'll go first. Mr. Chairman, members of the committee, my name is Tom Carter. I'm with Rocky Mountain Power, and it's good to be here with you this morning. Many of my points have already been made, and I just want to echo some of the things said by Mr. Taylor and Mr. Bush. This was a very iterative process. When you put together, when the legislature directs a group of stakeholders to come together to put legislation together like this, you are able to put down your swords and find common ground. I think it's really unique and a testament to the state of Wyoming that groups like our industrial customers, the Mining Association, the Petroleum Association, we're all able to find common ground to do something amazing here. We all know, and we are seeing that wildfire is becoming an existential threat to the West. And as Mr. Taylor mentioned, Utah passed similar legislation to this last legislative session last year. And now there are a number of states that have taken up similar legislation and that's working through their sessions, including Arizona, Idaho, Montana, and Oregon. And it's an important process. It's an important way for us to protect the states. As was mentioned, this is not about immunity. This is about a standard of care. This is about putting holding utilities accountable for wildfire mitigation. Earlier today, Mr. Schultz emailed the members of the committee Rocky Mountain Power's wildfire mitigation plan for Wyoming. Now, other states require that Rocky Mountain Power create wildfire mitigation plans, and if one state requires it, we will do it in every state. And so we produced a wildfire mitigation plan last year for the state of Wyoming, and we will continue to produce those plans. And the goal there is to do everything we can to ensure that we are not the cause of wildfire, to ensure that we are hardening our lines, to ensure that we are clearing brush, to ensure that we're doing the things we need to do to be part of the wildfire solution. To Senator Boner's question, we do agree with Mr. Bush that on page 3, Romanet 2, and page 4, Romanet 4, that the issue that he brought up specifically will be covered there, and that the plans will include maintenance of infrastructure to ensure that we are not part of the problem, because we want to be part of the solution. And this standard of care also, as outlined in the bill, recognizes that this is a big state and that we can't have a one-size-fits-all solution for this state because there's different topography and different, the state is just different in the best way possible. I didn't get a lot of sleep last night.
You guys feel good about what he just said?
In the best way possible, Mr. Chairman, in the best way possible. I love it here.
Go ahead, Mr. Carter.
Yes, so as mentioned, with this standard of care, we are asking for some liability coverage. We're not asking for immunity, and the liability is tied to action. And I think that's important, right? It's just not you get liability. It's you have to do these things and the commission has to approve that you do these things before we will contemplate this liability. And I'll also mention that the financial markets, insurance markets for our industry are watching this legislation and are very bullish that the states that do pass these legislations will provide opportunities, better opportunities for those utilities. And with that, I will pause for questions, Mr. Chairman.
You bet. Questions for Mr. Carter? Thank you, Mr. Carter. Mr. Schultz, did you have anything?
Mr. Chairman, Shane Schultz on behalf of Rocky Mountain Power. Don't have a lot to add other than, as the description was mentioned in, I believe it was page 3 of kind of what the details are of the mitigation plan. In some of the conversations we've had with some other parties, it gives some good detail, and I think you can see from the email that I shared this morning of Rocky Mountain Power's wildfire mitigation plan. These are not one-page documents. These are very detailed. And in order to go through that process and if this bill passes, get that approval from the Public Service Commission, just wanted to help you understand, this isn't a one-page, there are no trees in my county, here's my plan kind of document. It's a very detailed plan. So I just wanted to make sure, in addition to what was mentioned here, you had a chance to see that copy of Rocky Mountain Power's plan.
You bet. Thank you very much. And I just might, general question for both of you. I think in the bill, it says that you have to update the plan every 5 years. I'm sort of familiar with another planning process, the integrated resource plans, and they tend to get re-updated every year, but I don't think that level of attention would be necessary for a wildfire plan. But what do you think?
Let me just, Mr. Chairman, great question. Let me just double check here. I do believe, and I'm pulling the bill up now, but I do believe that we do have to update it annually. Page 4, is there, let me just look back at my team here.
I don't know, at the beginning, it says each electric utility shall prepare a mitigation plan that shall include a minimum. And then one of the minimum things is is Romanet 5, a description of how the electric utilities wildfire mitigation strategies and policies have changed in the immediately preceding 5 years.
That's right. And then but there is an annual reporting element as well. And I'm just trying to find it in the language. Here.
We'll find it.
Page 8.
Page 8?
Should have these things memorized, I'm sorry.
Yeah, like C there on page 8, the middle, in gross bill, everybody. Each electric utility shall submit subsequent updated plans to commissions not later than every 5th year.
Yeah, and then D, no later than June 1st of the following year, any year in which the commission approves a wildfire mitigation plan under this section, electric utility shall file an annual report with the commission detailing the electric utility's compliance with the approved wildfire mitigation plan and shall request an order of the commission finding that the electric utility has substantially complied with the plan during the preceding year.
So it sounds to like, Mr. Carter, the structure is, you got to update it every 5 years, and then you report on compliance with the plan. It's not like an integrated resource plan where you kind of do a evolving update as you go along. And that's fine, I'm not trying to push it in that direction.
I think that's what we have in statute, but I will say, because it's an ever-changing process, we will all, I don't want to speak on behalf of my sister utilities, but because it changes so often, we will continue to update and file and work. But I think the mandate of 5 with the annual report is the place we landed within the negotiated process. But we are constantly updating plans to ensure the best possible outcome for our customers.
Okay, I think it's great. Anybody else? Thank you both. And yes, sir.
Good morning, Mr. Chairman, members of the committee. My name is Sam Kidd. I'm here on behalf of the Wyoming Industrial Energy Consumers. We don't often get to testify on the same side as our friends in the utilities, but today we do stand in support of the bill and echo Mr. Bush's comments and stand for any questions.
Thank you very much, Mr. Kidd. Any questions from Mr. Kidd? Thank you very much. Appreciate it. Mr. Moline, welcome.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau Federation. We were graciously invited to be a part of this working group.
They're empty chairs, so hold on, I didn't mean to interrupt you. They're like prairie dogs poking out of holes back there, but they're,
I believe that was an issue that was in front of you yesterday.
no, that was
Committee.
Senator Boner.
Sorry, I digress. I apologize.
Go ahead, Mr. Moline.
Thank you, Mr. Chairman. I'd like to see this bill go forward. As I said, we were part of this group. I think I'd like to see it go forward. I know there's going to be some amendments going to come forward that'll, in my opinion, will probably strengthen this bill, like about providing notice. One thing I do want to say, my coworkers and I visited about this bill, and this is going to put some impetus, some responsibility on the landowners. And, to have a say in the plan, to make sure that their concerns are addressed. And with Farm Bureau, we commit to that we will work with our membership to get this information out to help facilitate the landowners being a part of this process. With that, Mr. Chairman, sitting in support of the bill going forward, I would take any questions you or the committee may have.
Thank you, Mr. Moline. Questions from Mr. Moline? Senator Landon.
So, Mr. Chairman, just to clarify, Mr. Moline, that includes on the front end this mitigation plan. Is that the reference that you just made, that we're going to be a part of this? It's going to be up to the landowners to make sure that they're helping on the mitigation front? Is that kind of
Mr.
where you were
Moline?
headed with that, or?
Mr. Chairman, Senator Landon, yeah, when these plans are going to be drafted, that's where it's going to be important for the landowners to know about them, to be aware of them, what's in there, what's not in there, and to have their input into the plan to make sure that it's beneficial to not only the utility, but to the landowner as well. Because we represent the landowners. Utilities are important, but we work with the landowners. I hope I answered your question, sir.
Senator Landon.
Yeah, I think so. Thank you.
Thank you, sir. Thank you, Mr. Moline.
Thank you.
Mr. McGagnon, welcome.
Thank you, Mr.
You
Chairman.
got the short chair there, sir.
I did, and that's where I like to be.
Okay.
Well protected.
Go ahead, Mr. McGagnon, welcome.
Thank you, Mr. Chairman. Jim McGagnon with Wyoming Stockholders Association. In beginning, I would ask your all experienced senators that you note this rare occasion when there's ag unity up here today.
I've only seen it a few times, Mr. McGagnon.
And with that, I would agree with the comments made by the previous speaker. We were a part of this working group, and I've been a part of many working groups over my career. This one worked as hard as about anyone I can think of, and we all gave a little bit. We found some success with the things we worked on. And I believe this is something that can work for the landowners in Wyoming. As was mentioned, there will be a couple of minor amendments coming forward that we would support as being critical to this, and they have to do with making sure that we can continue to do business the way we have, that the date of July 25 doesn't cut off our ability to negotiate easements the way we've always been able to negotiate easement. That one is important to us, but for overall, we think this has worked well and can work for landowners as well, because certainly we want to be protected if we suffer damage as a result of a fire. But more important than that, we want every step to be taken by all parties that will minimize the risk of fires taking place. And by requiring this upfront planning and approval by the Public Service Commission, we think that is a major step forward in assuring that fires will become less frequent, and that's important to us. So with that, Mr. Chairman, just offer our strong support of the legislation, and be happy to entertain any questions.
Thank you, Mr. McGagnon. Questions for Mr. McGagnon? Senator Boner.
Thank you, Mr. Chairman. So it was mentioned before that there's an opportunity for the landowner to weigh in on the plan. I'm just, you point me to the part of the bill where it says that there's only a few specific mentions of the landowner. Is there a more general provision that allows anybody to kind of weigh in before the commission? I'm just struggling to find where that's at.
Mr. McGagnon.
Mr. Chairman, Senator Boner, looking at the I guess two things. One, I'm looking on page 7 where this goes before the commission, and that's a public process. As obviously every landowner isn't going to get a direct notice, but you will see in an amendment that's coming that notice will be provided to counties, to conservation districts, and there's kind of a list there that we think provides the opportunity, and we all engage that landowners can become aware of this and have the opportunity to review and comment on these plans. So I would defer somewhat till the amendment is presented to you, that I believe addresses your concern there.
Okay, secret plan, Senator Boner. Anybody else? Thank you. Thank you, Mr. McGagnon. We're going to also hear from the commission about what this approval happens there. So thank you very much. Yes, welcome. How are you? Ms. Stewart, right? Ms. Stewart, why don't you go next? Make sure your green light's on and get her close.
All right, thank you.
Welcome.
Thank you very much. Good morning, Chairman Case and Senators. Thank you very much for your hospitality this week. My name is Victoria Stewart. I'm the Legislative Affairs Director for Farmers Insurance. And I have the honor of representing our small business owners and supporting them, our agents across the state. We are unfortunately in opposition to.
A sec, maybe we have too many green lights there?
Oh, apologies.
No,
In opposition to HB.
Sometimes.
Oh.
I'll shut mine off, you go ahead.
Okay, 192. The immunity granted to the electric utilities in this bill would have an adverse impact on an insurer's ability to recover on behalf of our policyholders. When an insurer pays a homeowner's claim after a wildfire, we step into the shoes of our policyholders to hold those responsible for the loss of their home and property financially accountable. Just like in an auto accident, the at-fault party pays the claim to make the injured party whole again. HB 192 circumvents this process using the undefined substantial compliance, removing it from the courts where a judge or jury makes this determination, and placing it in statute, asking the Public Safety Commission to decide instead. The bill states an energy utility shall request an order of the commission finding that the electric utility has substantially complied with the plan during the preceding year. This is all a utility has to do to secure immunity from liability if its equipment starts a wildfire in Wyoming. We provided amendments to define what substantial compliance for utility could mean in order to convey this level of liability protection to utilities. We would request utilities to have already complied with the work defined in their wildfire mitigation plan, or have requested access to do the work outlined in their plan if denied or delayed access to the land if their equipment is found to be the cause of a fire. This way, there will be no question about whether the utility is in compliance with their wildfire mitigation plan. We want to get this right because providing immunity to utility or shifting responsibility to the homeowner or the landowner may lead to challenges with availability and affordability in high wildfire risk areas. In effect, immunizing utility shifts the responsibility for unsafe conduct from the entities with control over safety to those who have no control and are most likely to become the victims of utilities' potentially unsafe conduct. Nearby residents and property owners, both insured and uninsured. A homeowner who is uninsured or underinsured would be left with no remedy. And one of the things that was mentioned was the Arizona, this bill's running in several states. Actually, in Arizona, the bill did not pass. It failed passage in the House there. So there are issues with this bill, and there are questions that are coming up about kind of granting this level of immunity. That was one that actually it failed passage last week, or this week, actually. And so I'm here if you have any questions, and I'm happy to.
Yeah, I'm going
pass
to
it on
put
to
my
my
mic back
colleagues here from
on.
Munich.
Committee questions for Ms. Stewart? Senator Doc Stater.
Thank you, Mr. Chairman. Ms. Stewart, appreciate your professional approach and presentation. Are you aware that we have worked this piece of legislation all through the interim, and Mr. Taylor brought together a group of stakeholders, worked it and worked it and worked it. In fact, we sent him back to the drawing board several times so we could get to this point. Speaking of Arizona, they can't get it right. We can. We brought it to the table, and as you just heard, we've heard all the stakeholders come on board finally and say, here we are. We've reached our quote unquote 80% mark. We're here. you have any concerns about that?
Ms. Stewart?
Mr. Chairman, Senator, I have heard about the conversations that have been going on. Unfortunately, I recently became engaged in those, trying to get involved from afar, and I apologize for not being engaged earlier. I'm trying to reach out I am trying to get involved now. I unfortunately would have liked to have been involved earlier.
We're glad you're here, right? So,
I'm glad I'm here before it's over. Is I guess my hope that we can still continue the
Mr.
process.
yeah, Senator Landon.
So, Ms. Stewart, thank you for being here. Appreciate it. Can you just help me encapsulate your concerns with the bill? Can you reiterate that real quickly in about 3 sentences? What's your concern? You bring up the word immunity. The other side indicates that they don't believe it's complete immunity. Can you zero in for me what the concern is of farmers insurance?
Ms. Stewart.
Mr. Chairman, Senator, the concern here is the economic impact of this doesn't go away. It moves. So the cost that happens here, it's going to raise rates somewhere. So it can either be on homeowners insurance or it ends up on utility. And I guess it's kind of a choice. It can be on individuals or it can be on utilities and finding it in that space. So being the place, our concern is the prevention is the most important part of this. And there is a question of making sure that that's the part that is focused on. The liability prevention, I guess there's a fear that if you shield liability, there might be a decrease in that focus on prevention.
Thank you. Appreciate that.
Thank you, Senator. Anybody else? Ms. Stewart, are you aware, and I don't know, I don't believe that the working group had any insurance company representatives, or did it? People are nodding, okay. So I guess that's not a very good question for you, but I think.
I think it's property casualty is the one that, the homeowners insurance.
Right. Okay. Thank you for that, and probably was an unfair question, but I got a lot of nodding from the back of the room. We'll hear more about that. Did you have anything else?
I will turn over to my learned colleagues near me.
Okay, we'll go to the gentleman first because he was at the table next. Go ahead, sir.
Oh, thank you, Chairman Case, members of the committee. Thank you for allowing me to go first. I think the order will make a little more sense that way. I think my name is Brandon Vick with the National Association of Mutual Insurance Companies.
Okay.
And I think the theme of our panel can kind of be summed up with a term that predates my time, but now for the rest of the story.
Okay, and it's Vic?
Vick, V-I-C-K.
Got it. Thank you.
Yes.
Keep going.
For reference, NAMIC membership reflects many of the country's largest national insurers as well as local and regional mutual insurance companies on main streets across America. We represent 61% of homeowners insurance policies, 48% of automobile insurance policies, and 25% of the business insurance market across the U.S. We do want to recognize the work that has been done on this bill from its inception last year. It's in a better place than it was. The amendments that have been taken have made the bill better. But we also believe that we are a long way away and have real concern that this legislation as proposed will result in Montana residents losing their only real recourse to be made whole in the event of a utility-caused wildfire.
Do you want to correct your oop that you just did? You're in Wyoming, sir.
I do. I would like to apologize dramatically, and I don't know. I will highlight that and come back. Yes, that's. Should I just leave now?
No.
Or can I finish?
We love
Okay.
Montana, and
Oh, my
we
goodness.
understand that.
As mentioned, there's several states working on legislation like this, and I cover 4 of them.
Yes, sir. Go ahead. It's okay.
While you might expect us to be concerned only with the insurance provisions of this bill, the fact of the matter is that
Take a moment.
many Wyoming residents remain uninsured or underinsured on their properties. Passage of this bill will largely take away or make more difficult their opportunity to recoup their financial losses through civil proceedings in a potential tragic loss of their home or property. Insurers are in favor of wildfire mitigation plans. Risk mitigation in general is very important to us as an industry. That's kind of what we do. We believe that all utilities should have such plans and know that many of them do today. Working to reduce the risk of wildfire is a social responsibility that we all take seriously. That responsibility should extend well beyond this piece of legislation, but I'd also suggest that if you wanted to take up a bill specifically requiring utilities to have a wildfire mitigation plan, I think that's a great standalone idea. What we are not clear on as to why there should be any type of special liability or damages standards for property damage that is caused by utility equipment. Insurers favor a system in which businesses, individuals, and even quasi-government agencies are held responsible for the damages that they may cause, regardless of whether that damage is an act of malice, result of negligence, or purely accidental. Wyoming residents are still in danger of losing their homes, their lives, and their livelihoods when a fire inevitably takes place. Limiting the exposure of an electric utility does not decrease the overall cost to the economic ecosystem. Someone is going to have to pick up the bill. Litigation is a major cost driver in the insurance industry, and insurers need to be able to recoup their losses in the event of a wildfire. Adding these costs to insurers will simply shift that burden to the home or property owner due to higher costs of doing business, and in all reality will probably make the availability of homeowners insurance and property insurance more difficult to find. And let's not forget that those who are underinsured or have gone without insurance do not have the same resources. They don't have the high-priced lawyers and the fancy suits to go fight these battles. Are they going to have the ability to retain an attorney and go fight in court for the justice that they deserve? We hope and believe that all utilities are doing everything that they can to clear vegetation and properly maintain their equipment. I don't think there's a utility in Wyoming that's going to intentionally start a fire, but in the horribly unfortunate circumstance that a wildfire is started by a utility, costs need to be able to be recovered in a timely manner without excessive legal hurdles. Passing this bill as written will undoubtedly shift costs from utilities to insurers and Wyoming citizens. The question remains how much? We don't know that answer. We're not going to know it till we see the next fire. But as costs increase, rate increases are likely to follow. Please remember that if a wildfire does occur, the costs still have to be picked up by somebody. Again, we appreciate the work that's been done. We don't think this bill is ready to go. We will have a series of 4 amendments that I think are made in good faith to protect the property owner while preserving the ability of the utility to engage in their mitigation efforts and receive some benefit from that. But today we believe it's still too open-ended and there are too many questions, and ask you to oppose the bill.
Okay, thank you. Questions for Mr. Vick? Questions? 2 questions. Are you an attorney, sir?
I am not an attorney.
Still have a nice suit, though.
I do have a nice suit. Before this, I spent 10 years in the Washington legislature.
Oh, boy.
I was in the minority the entire 10 years, but that's okay.
Well, welcome. Who's going to provide the amendments? And Ms. Shaner. Okay.
Yes.
Thank you, Mr. Vick. I think you're off the hook. Ms. Shaner, welcome.
Thank you, Mr. Chairman, members of the committee. Mary Ann Shaner here on behalf of State Farm Insurance. And I will present the amendments. You should have received a copy via email, as well as I did distribute those through the secretary. So the first amendment relates to substantial compliance. And what we would propose is on page 8.
I think we're just getting a Ms. Shaner. Hold on 1 second. Looks like maybe this could give us the Steinmans down there. Okay, I'm sorry, we do have them.
Thank you.
This one?
Yes, that is correct.
Okay, go ahead.
So on page 8, line 20, deleting the balance of the line after and inserting a period, and then deleting on page 8, lines 21 through 23, the language that says on an annual basis that the utility requests that the commission find that they're in substantial compliance with the plan. And our concern with this provision as it stands is that, as we've heard before, this is a rebuttable presumption. A utility will be held liable if one, or cannot be held liable if one, they're in substantial compliance with their plan, and then second, that was the actual and proximate cause. So the substantial compliance, we have concern that this language could be used to determine whether a utility was in substantial compliance with their plan, and a court, it takes it out of the jury's hands because the PSC is making that determination in advance of a court case in the event somebody is trying to recover for a wildfire. So we have concern that it's unlikely that landowners are going to go to the PSC on an annual basis and express their concerns regarding whether or not these utilities are in substantial compliance with their plans. So we feel that that part should be up to a court of law in the event that there is a utility-caused wildfire. Moving on to the second amendment. Our concern with this bill on substantial compliance is that if you turn to page 10 of the bill, and you look at lines 2 through 9, what the bill does is it defines what substantial compliance is. It says, for purposes of this paragraph, an electric utility shall be deemed to have substantially complied with a wildfire mitigation plan if the electric utility attempted in good faith to comply with the plan, but was denied or unreasonably delayed access to a right-of-way after the electric utility requested access to the right-of-way to perform vegetation management or fire mitigation work in accordance with the plan. That is a definition for this paragraph of what substantial compliance means. So in essence, the only time that you could be determined to not be in substantial compliance is if an electric utility, attempted in good faith and was denied access. I don't believe that that is what the intent of the bill is, but that's what the language reads. That's very concerning because it would be a very limited circumstance in which you could actually prove that somebody substantial or that the utility substantially complied. It would only be in a case where they were denied or unreasonably delayed access to comply with the plan. That's the only circumstance in which a utility would be deemed to not have substantially complied with their plan. As such, we would request that that language be stricken and that a definition be created for what substantial compliance means, which is what we have included in Amendment 2. Amendment 2 is language that is based upon the Utah law that has been discussed, that was passed and agreed to in their bill. And what we would like to do is have it be that an electric utility will be considered in substantial compliance and may not be considered to have negligently caused a wildfire if the cause of the wildfire, so in the circumstance, for example, that Senator Bona raised earlier of a line that is the cause, that's in the mitigation plan, and that the origin of the wildfire, and this is to the point that my colleagues made earlier, is that the actual actions under the mitigation plan have occurred. Because again, this is a fundamental shift in Wyoming law to provide immunity to somebody. So in order to have that immunity, you should have a plan. It should identify the specific cause of the wildfire or causes of the wildfire and the actions under the mitigation plan, including inspection, repair activities, modification or upgrades to the facilities, et cetera, should have actually occurred at that spot in order to have immunity. And then we do understand the circumstance where you may have a tree on BLM land and that you're requested access, and we all know how the federal process works, and you may not be able to get to that tree to cut it down because the BLM hasn't given you that permission. And so that's what subsection 2 on our proposed amendment is intended to address. Subsection F relates to an ability for a person to incur costs, to recover those costs for suppression of a wildfire. And then subsection G is in relation to providing that a property owner can recover in the circumstances in which a utility is not in substantial compliance with the plan. Moving on to amendment number 3. This is a critical amendment to the insurance industry, to my colleagues that were up here before. This is a circumstance we understand, and we're not saying that the utilities are requesting complete immunity from everything. What our concern is that you could have a circumstance where there is a known line that is causing issues that's not a part of their mitigation plan. And that line causes a fire. Under this current draft of legislation, they would be immune from liability because you can only recover in the circumstances that you show that they weren't in substantial compliance with their plan. But in this case, that line wasn't a part of their mitigation plan. So you cannot meet the burden of proof in order to recover. So that's a very concerning circumstance in which you could have potential negligent actions that weren't included in a mitigation plan, and then the utility gets immunity. Moving on
And
to,
just, so it says not explicitly covered.
that's correct.
So you're looking for fine granular detail, I take it.
Yes, Mr. Chairman.
Okay, keep going.
Amendment number 4 is in a situation, and again, this goes to the discussion regarding complete immunity. Again, our concern is in regards to that you do have something outside of the plan that causes a wildfire. You know, you have a utility pole that was hit by a vehicle. It hasn't fallen down. The utility is completely aware that that utility pole was hit by a vehicle. It's not a part of the mitigation plan. It falls down, causes a wildfire. They would be immune under this because you cannot meet the burden of proof in order to recover. So we do appreciate the working group. I did participate on that. I do believe that there are a number of concerns. We've tried to work with the utilities on these amendments yesterday. So we support these amendments, and I would stand for any questions.
Okay, question, Senator Landon, start with you.
Ms. Shaner, thank you very much. Very, very comprehensive and a lot to digest here. Were any of these amendments considered on the other side?
Go ahead,
Mr.
Ms.
Chairman, Senator Landon, the request of the working group was that nobody provide amendments so that the bill could get out. So some of the amendments in similar form were discussed on third reading that were brought during that time.
So it's usual House just says, let the Senate do all the cleanup, pretty much standard. Sounds like it. Senator Dockstader, do you have something?
Thank you. Mr. Chairman, I would hope that we'd have the other side respond to some of this. This is my
We
concern. They've worked long and hard, Ms. Shaner, and I appreciate your work, but they've worked long and hard to find some protection for our member-owned co-ops. These are people across Wyoming that run these co-ops. And I sense and I feel that your organization is taking away from the long, hard work that has been accomplished to this point. Your response to that?
Ms. Shaner?
Mr. Chairman, Senator Dockstader, we appreciate the significance of wildfires and the cooperatives in Wyoming and the working group that has happened. But I do feel that this bill is not ready for prime time without amendments. I mean, at the last Minerals Committee that it was discussed, there were lots of questions. And despite the fact that there have been amendments, you know, we attempted to reach consensus and work on this with the utilities, and the process is very fast, as you know. So we do not feel comfortable that the bill is in the shape that it should be to move forward.
Thank you, Ms. Shaner. Anybody else? Thank you. Let's go, Ms. Vance. Who's going to go first? I'll let you guys choose. Ms. Wilkinson.
Mr. Chairman, members of the committee, Catherine Wilkinson, wearing two hats before you today, Mr. Chairman. I was not planning on speaking until you had asked if anyone was part of the working group from insurance. So I guess briefly, on behalf of American Property Casualty Insurance Association, we were part of the working group. We are neutral on the bill. We are in support of the insurance amendments.
Okay.
And so I would stand for any questions on the insurance side, Mr. Chairman.
Okay, anything at this point? Go ahead.
Mr. Chairman, while I am up here, I am also representing All West Communications, also in support of Ms. Levin and Charter's amendment as well.
Okay,
So thank you.
got it. Anybody else? Thank you. Ms. Lance, welcome.
Thank you, Mr. Chairman. Beth Lance, here on behalf of the Wyoming Child Lawyers Association. We do have concerns with this bill. For clarification, we were not part of the interim working group, but we have had some meetings with utilities regarding this bill. Certainly agree, as I think everyone does, that wildfire mitigation is incredibly important for Wyoming. And so, we want to be clear about that. And one of the main concerns I wanted to bring was in regards to an amendment that was put on that we would request this committee to remove. That is the amendment that created the requirement to negotiate, that a landowner that has been harmed is now required to negotiate with an electric utility and give them up to 90 days to respond to them prior to being able to bring an action potentially in court. That amendment is on page 9. It's lines 9 through 15. That is a great concern. That is a block to a constitutional right to utilize the court system. Additionally, the other concern is it's creating this 90-day timeline in which if that individual was up against the statute of limitations that are contained within this bill, they could be completely denied their ability to ever go to court if they are required to do this kind of outside negotiation prior to bringing an action. So that's certainly a concern that is new to the bill that I wanted to raise. Additionally, our members also have concerns whether the current status of this provides any possibility to bring an action under a negligence situation at all. The language that Ms. Shaner brought forward is a concern on our part as well. Our members support all of the amendments that were just provided by Ms. Shaner and her clients. And we do think that that would help make this bill better to adopt those amendments. Certainly, we understand issues with rising costs of insurance and that has created some concerns for utilities. Obviously, it creates concerns for individuals. I think we can all agree everyone's.
Can I interrupt you?
Absolutely.
Just by way I can see, we've got a House sponsor out there. We're not going to get to any of the election bills that we have on the two that we have on the list. I'm just doing housekeeping. We'll be lucky to get to the next utility bill. And Representative Stivar's out and back there. Would somebody tell him that we're not going to get to him? We'll take it up on Monday in order. Appreciate that. Sorry about that, Ms. Lance. Didn't mean to interrupt you. I apologize.
No
Go ahead.
problem, Mr. Chairman. Thank you. That's essentially my testimony. I would just request that this committee look at providing a balance between the rights of individuals that could potentially be harmed and the needs of the utilities.
Okay, thank you, Ms. Lance. Questions for Ms. Lance? Questions? Thank you very much. Mr. Nicholas, welcome.
Thank you, Chairman Case. Last time I was here, I said that was the last time. I hope this is my last time here.
Never know.
They
Welcome.
never know. They keep bringing me back in. I feel like it's Godfather 3. We proposed some amendments that are being passed out right now. These amendments have been approved by the working group, and they cover many of the concerns that we had initially with the letter that we sent to the committee. The first amendment is on page 11, lines 12 through 14. This is regarding section 2, regarding the preemption concern that we've shared. The amendment would remove original and also would remove made before July 1st, 2025. And so now would read, nothing in this act shall be construed to impair, alter, or preempt any terms or agreements and grants of easements. We'd be okay if we said grants of easements or other agreements and address the charter's concern. Amendment 2 is on page 7, lines 1 through 4. We would just add in the bold wording with the list of entities that would receive input, but we would just include counties to that. That would. And the idea behind that is we want to make sure that these plans are robust. The only way we can be comfortable with this is if counties are involved and local landowners have an ability to be involved in these plans. And so having these plans be robust and have the scrutiny of the locals who could be affected by fire that's the addition there. Amendment number 3 is also on page 7, starting at line 5. Would be inserting a new subsection, basically stating that no later than 5 business days after the fire mitigation plan is filed with the Public Service Commission, the electric utility shall directly provide notice that a wildfire mitigation plan has been filed with the Public Service Commission to the Wyoming Association of Conservation Districts, Wyoming Association of Municipalities and Counties, and the electric utility service territories. This once again just ensures that counties and other affected local governments, as well as hopefully landowners, can be in the process and will be involved with the Public Service Commission. That all being said, I think that the concerns of the shift of liability may still remain. However, these will help us tremendously in making us be comfortable with it. Alternatively, we would support the amendments that were just recently presented, but in the effort to not be a party pooper, as my colleague would say, we will support the bill if we get these proposed amendments.
Thank you. Questions for Mr. Nicholas? Questions? Mr. Phelan, welcome.
I have nothing.
Okay. Anything? Thank you both very much. Appreciate it. Who else? Come on, we're gonna have empty chairs here. Mr. Acey, let's get you up. Let's fill it out. I'm not seeing anybody else in the room who's going to testify on this afterwards, so, except for the agencies, of course. Mr. Acey, welcome.
Thank you, Mr. Chairman. Bruce Acey, appearing here today on behalf of MDU Resources, which includes Montana Dakota Utilities Company. Montana Dakota serves customers in northern Wyoming. We also have services in Montana, North Dakota, South Dakota, and Minnesota. We have related companies that serve in Idaho, Oregon, and Washington. So we have a broad footprint with respect to what we serve. We've been involved in the wildfire issues, and particularly with respect to the legislation that's been ongoing. We've been involved in the process, not only in Wyoming, but also in Montana, North and South Dakota. So we are very interested in this program and speak very strongly in support of what the stakeholders have done. You know, a couple of years ago, when I was a staffer with the Wyoming Public Service Commission.
That's more than a couple of years ago, Mr. Acey.
It was a generic term. I participated in a proceeding in which an attorney, Mr. Jerry Spence, appeared and testified on behalf of what he characterized as Mrs. Murphy. And Mrs. Murphy was the ratepayers that he was there appearing for. And it's interesting as we view the legislation that we're proposing here, because it's a question as who is representing Mrs. Murphy and protecting her interests in the legislation. I would submit to this panel that in fact, in working as a group, we were trying to fashion, if you will, a balance so that we could protect all interests, including Mrs. Murphy, because not only is she an insured, as we've just heard from, but she is a ratepayer, which we need to protect. But I'm going to go one step further and suggest to you that in many respects, she is a stockholder in my company as an investor-owned utility. And her retirement is up there, and she's relying on that as she goes into her fading years and wants to ensure that my company protects her interests too. So in using this legislation, we've been trying to, fashion something that would benefit all parties. It's unfortunate that we have some late amendments. I think perhaps because of the recent events in California, maybe individuals and companies woke up and say, well, we need to address this, but they forget the process that we've gone through since, the beginning of the summer to fashion a compromise that would work here. I'm going to suggest that I speak for the utilities in one respect, and if they object to this, they can object, but just to move this along a little quicker, I'm going to suggest that Montana, Dakota, and I believe the other utilities, with respect to the amendments, we support the charter amendment. We also support the amendment that was just provided by, I believe, the landowner group. We do object and oppose the 4 amendments that were provided just now by the insurance companies, with the exception of amendment number 1, which we can live with. But as to amendments 2, 3, and 4, we very much do disagree with them. We disagree with them because we believe that the amendments, in many respects, undermine the nature of what we were trying to provide in the legislation in a compromise. In certain respects, it might expand the immunity far beyond what they would have anticipated, particularly as you look at the Amendment 2. It creates a loophole.
Talking about the insurance company amendments.
Yes.
Yes, sir.
It creates a loophole in the liability standards that we would like to avoid, and it weakens consumer protections. We say that because as you look at particularly Amendment 4, as we look at that, we believe that it creates an ambiguity in the liability standards. What we attempted to do in fashioning the bill was create a bill that put an onus on utilities to be proactive in what we did in preventing wildfires. And so we have to prevent it. We have to present a plan that has to be approved. There is a concern that everybody participate in that process. And in fact, you saw the recent proposal that would enhance the notice so that everybody would have an opportunity to participate in the approval of the plan process. We use that to ensure that we address the concerns of landowners and other, interest stakeholders who might be interested in the plans and ensure that we're addressing concerns that may cause wildfires. That is a public process, and we have emphasized that as part of the plan so that everybody can be involved. You're going to hear from the Public Service Commission, and they will be the ones that will be controlling that. We believe that the amendments proposed by the insurance companies weaken that particular plan and the process that we're going to use in that. And so that's one of the reasons we oppose that. We believe that the legislation as we propose provides a clear framework, a clear process to address the issues that need to be addressed, even those of the insurance companies. We also believe that the amendments shift the focus away from compliance and being proactive in preventing forest fires and away from the mitigation plans that we proposed. And because of that, we object to them. We also believe that it enhances litigation, that we're trying to prevent, in many respects, from, by using the proposal in our legislation that we're proposing. We also believe that it undermines the intent of the bill by undoing the balance that we're trying to create. We understand that anybody in this room can come up here and say, hey, I'm getting a bad deal. I need to enhance my position. But on the whole, we believe the plan appropriately balances, the interests of all those who participate and the public. And you'll hear from the Public Service Commission, their primary purpose is to ensure that they protect the public interest. And that includes all interests. I'm going long, I need to get out, but I appreciate the time that you're giving me to listen to our concerns, our support for the bill, and concerns with the last amendments. Thank you.
Thank you. Any questions for Mr. Acey? Senator Dockstader.
Mr. Chairman, Mr. Acey, as I understand it then, those amendments provided by the insurance companies, you're okay with amendment number 1?
Could live with it.
Yes,
Live
I
with
could
it,
live
think.
with it.
Yeah.
All right, thank you. And Mr. Chairman, a follow-up then, where we brought these amendments on past the time that original people have testified and those who actually prepared the bill, are they going to be allowed time to come back and respond to those amendments?
Well, Mr. Senator Dockstader, we're going to do the best we can. We'll see how we can pull that off. We want to get this bill out today, so thank you, Mr. Acey. I don't see anything else. Thank you. Okay. All right, let's go to agencies. Who's next? Chairman Throne, welcome. Mr. Ornelius, welcome. Mr. Burbridge. Welcome. Go ahead.
Good morning, Mr. Chairman. Mary Throne, Chairman of the Wyoming Public Service Commission. And with me from our side of the building is our Chief Counsel, John Burbridge. And I'll let Mr. Ornelas introduce himself, because I do not speak for him.
Mr. Ornelas.
Good morning, Chairman. Anthony Ornelas with the Wyoming Public Service Commission, or I'm sorry, the Wyoming Office of Consumer Advocate.
You just almost gave up the right to speak for yourself. Okay, Commissioner.
It's almost as bad as the Montana-Wyoming.
It's early. Let's go.
Anyway, Mr. Chairman, as you know, we do not take positions on bills. We participated in the stakeholder group to ensure that the mechanics could work for us, and appreciate the stakeholder group, including us. We have the authority now to require utilities to do wildfire plans. As you know, we have broad authority. But I think putting it in statute, emphasizing it certainly, and basically expanding the people that we would have to reach out to, is beneficial. The utilities are not responsible for the weather, but they are responsible for safe, adequate, and reliable service and maintaining their facilities. We already subject them, the collective, the regulatory community subject them to vegetation management standards already. So the wildfire plans will go through our normal contested case process. This is not going to be a rubber stamp exercise. We had some concerns about the 120-day timeframe, but the amendment gives us the flexibility to extend that for good cause. We do this in other places in the statute, in the securities area, for example. So we're comfortable with the mechanics as structured. We do not make policy calls on liability. So that's the bit of the bill, more than a bit of the bill, that we do not have existing authority to limit liability for utility companies.
Fair enough. Questions for Commissioner Throne? Any questions? Mr. Ornelas.
Thank you, Chairman Case. Once again, Anthony Ornelas, the Wyoming Office of Consumer Advocate. We also were part of the working group. We appreciate the efforts of the working group. I would echo Mr. Acey's comments in somewhat disappointed in some of the late amendments. Some of these parties were part of our working group, and to have them come this late is concerning. So on the fly, I will just say that some of the recent amendments we've heard would cause some potential issues. Calling out explicit assets, that was one of the amendments in there that I think you had asked a question on, Chairman. That's a whole level of detail that I don't think we currently focus on in our industry. We're gonna have to call out individual poles. That's gonna be a different level. We call out segments, we call out sections, we look for high-risk areas. We focus on line miles. So that specificity does cause me some initial concern. Secondly, I think I would, I guess, caution. Some of the things I've heard today is a need or a place for people to litigate when they're uninsured or when they're underinsured. I don't think utility rates are the place we want to do that. This is really a bill that limits the long-term liability risks to a utility when they are acting prudently and safely. There is nothing in this legislation that limits a landowner's or an individual's right to seek litigation if a utility has acted imprudently or unsafely. Senator Boner had given an example. If they're not engineering their lines right, if they're overloading their capacity limits of their transmission, if they're failing to do mitigation, if they're failing to do the things we expect and demand of them, they are on the hook. What this bill, in my opinion, does is provide some guardrails when they are acting prudently to understand the importance of our utility system. I haven't heard it said today, but it has kind of become a nomenclature that every utility is one wildfire away from bankruptcy. And that will have consequential impacts to our ratepayers if we don't provide some guardrails and we find that situation to be the case as we have, as we're starting to experience and have seen in other states. And with that, I'll stand for questions. Thank you.
Okay. Questions for our consumer advocate? Questions? I think we're good. Mr. Burbidge, do you have anything?
Thank you, Chairman Case. I do not. The chairman seems to have covered where we are with this bill adequately.
Perfect. Thank you, guys. All right, did I miss anybody out there? We're gonna go online. I can tell that I missed somebody. Welcome.
Good morning, Chairman Case. Wyoming State Forester Kelly Norris here.
Oh, how do you do?
Good, how are you? Busy. I just wanted to testify real quickly and make a comment as Wyoming State Forestry is listed as a reviewer. And I do think it's really important to have wildfire subject matter expertise review the wildfire mitigation plans. In regards to that, most of the counties have community wildfire protection plans already in place for themselves. And it's really important to make sure that we're coordinating where our fire wardens and our local jurisdictions see the highest risk and already have those in their plans, and have this plan also coordinate in regards to that at the local level. We already, when it comes to wildfire suppression, coordinate fairly well when it comes to utilities and needing to turn off power. That happened quite a bit this summer. And I think this would bolster that coordination on the prevention side, making sure that we are all lining up where we see this highest risk to a community and in regards to a utility could be combined. And so we have no concerns being listed as a reviewer prior to that. That was what I wanted to make sure we comment on. One of the things I do want to note is the emergency fire suppression account is the account that pays for wildfire suppression for all private and state lands. So when we're looking at liabilities, when we saw the first bill in reiteration, there was some concerns about what you've been hearing about. Would the utilities be off the hook and then the state EFSA end up having to pay for those costs? It seems like that has been fixed, that this is very different than what we had seen on the original bill. And so I wanted to make sure that you were aware that our voice was heard as we brought those concerns forward, making sure that we wouldn't be, and also to recognize that fires run into other states. They run across a lot of boundaries and federal boundaries.
They probably get to Montana.
And just a few to Montana. We sent, I think, 5 or 6 this year, pretty big ones too. And sometimes Montana they burn into our state. So with that, The other important part I do want to note is we did bring forward also some concerns with the de-energization.
Energization.
Thank you. It's really important to have that be a part of these plans for first responders, to understand and know what's going on when we come into a wildfire setting, making sure there's a plan in place, and understanding how long that's going to take to bring back in these communities and all of those type of bits and pieces and parts. We're thinking I think that's really great to see this back input into that bill too. And so those were the main concerns that we had provided input on in that bill when it came to on the ground wildfire suppression at the time. And so with that, I would just leave it open for any questions you may have.
And Madam Forrester, is it Norris or Morris
Norris,
with an N?
with an N.
Okay, my
just
ears
like
aren't what
Chuck.
they used to. Stay with us. Anybody want to ask questions? Senator Landon?
Just a real quick question. I think that I heard you indicate that including counties in the paragraph at the top of page 7 would be a good idea.
Ms.
That's a
Norris?
suggested amendment that we got a few minutes ago.
Mr.
Go
Chairman, I have no concerns with adding counties into that list. The amendment number 3 that was brought forward in that list, I noticed we have Wyoming Association Conservation Districts, Wyoming Association Municipalities and Counties. There is not the state or the Wyoming Rural Firefighters or the fire wardens in that list. Just a note on that.
Anybody else? Ms. Norris, I have a question about the de-energization. And I know you're not a utility expert, but there was recently a national story, it was an NPR story, and it talked about the responses to the terrible fires in North LA, and talked about the interaction between fire managers and the utility. It was Pacific Gas and Electric, I think. And so they had this situation where the utility was saying that lines were de-energized but first responders were finding that lines were energized. And I happen to have a utility background. I'm pretty sure the utility was right, but what was happening a lot was that you had third-party generators where people were added generators, or they might have had solar facilities on their roof, and the ability to disconnect those, they're supposed to disconnect, but they weren't. So first responders were encountering down power lines that were still live, maybe not as much as they would be otherwise, but they were actually causing additional fires. So I wish we could get a handle on something like that. Have you thought about that?
Mr. Chairman, that is a great point. We had multiple fires start this summer based on homeowners and electricity and items just similar to those type of things. That's not utilities. That's really, we need to do quite a bit of education, I think, and preventative education on the impacts and the risks of when we have homeowners doing what they're doing with their own electricity in their homes or outside their homes, connecting to different buildings, lines on the ground. There's all sorts of things that go on.
Yeah.
And I think that is something we'll need to continue to do in preventative education and moving forward.
Thank you very much. It's another consequence of having decentralized electricity production in the grid. Thank you very much.
Thank you.
All right, I think we should go online. Let's have Jerry Spence first. I understand he's online.
He is, Mr. Chairman. Mr. Chairman, we have Mark Aronowitz and Phil Irwin online.
Let's take Mr. Aronowitz at first. I can see his face, so.
Good morning, Mr. Chairman. Thank you for allowing me to appear in this way. My name's Mark Aronowitz. I am the Executive Director of Lawyers and Advocates for Wyoming, a public interest, not-for-profit law firm. I want to take a moment to express a few concerns with this bill and to speak for the people who weren't part of the working group, couldn't be a part of the working group, because thankfully they don't exist yet. But the group is anyone in Wyoming who lost anything or everything in a wildfire. A general goal of any legislation, I believe, is to strike a balance but this legislation lacks balance in two very significant ways. First, the idea that public utilities get to write their own plan and that the Public Service Commission shall approve the plan, that shall is on page 7, at which point it becomes virtually impossible for anyone to bring a claim against them. It is effectively replacing a judge and or jury with the Public Service Commission. I would not say that this bill is total immunity. It's not. There are very limited exceptions by design, but it's pretty close to it, and that is the intent of the bill. Second, and this goes to page 9, subsection B. Subsection B was added to the bill over in the House, and it's mandating good faith negotiation. There's absolutely nothing wrong with good faith negotiation. It's something I always do in my own practice. But in this piece of legislation, it's quite heavy-handed. Again, public utilities get to write the plan. The Public Service Commission shall approve the plan. Subsection A on page 9 says that there shall be a presumption that the approved wildfire mitigation plan is reasonable and prudent. The 90-day delay is unnecessary because these negotiations in reality aren't going to go anywhere. If one side gets to write the plan and the plan shall be approved, and then that same one side gets a presumption, and the only way the affected party can prevail is if they show that the utility failed to substantially comply, but they can't file their case and they can't engage in discovery and they can't get the evidence they need to prove that the utility failed to substantially comply. The utility is never going to admit in good faith that they failed in any way to substantially comply with the plan that they wrote. And so these negotiations they're not going to go anywhere. They'd be nice if they were, but when it's set up to be so one-sided, that's not how good faith negotiations work. By comparison, if someone was to bring a claim against the state of Wyoming, you do have to file a notice of claim, but there is no 90-day delay. After you file that notice, you give them the heads up, and then you can file your case. So in a way, public utilities are being favored in a way that even state and counties and cities aren't with that delay. So subsection B on page 9 is just justice delayed is justice denied. And as I said in the beginning, we want balance in legislation, all kinds of legislation, but this is really heavily tilted in favor of public utilities, probably because the people that would get hurt could not, by definition, be part of the working group. But I think we have to think of them as well. I mean, they're my future clients, they're your constituents. People can lose everything in wildfires, and I just think we need to think of them too. So thank you so much for your time. Happy to stand for any questions.
Okay, questions for Mr. Aronowitz?
Mr. Aronowitz, and Mr.
Go ahead, Senator Dockstader.
Mr. Chairman, Mr. Aronowitz, you're aware that all the parties were invited to this process. You're suggesting that perhaps just the utilities are. That's my first question. And then I sense that you question the PSC's ability to approve this. Go ahead.
Go ahead, Mr. Aronowitz.
Mr. Chairman and Senator Dockstader, and I'm happy to answer your questions. I'd love to ask you a question as well. I think some of the parties here don't exist yet, so they could not be a part of the process. And I don't question the Public Service Commission's ability, but what is their ability if they shall approve it? It is mandated that they must approve this within 120 days. So I'm sure they have the ability to analyze it. I'm sure they have some expertise, but where's the discretion if there's a shall? And my question, if I'm permitted.
Go ahead. Rhetorically, maybe.
Well, if someone on this committee is the chairman of a board of a public utility that stands to benefit from this legislation, how could there not be a conflict?
Thank you, Mr. Aronowitz.
May I respond?
You certainly may.
Thank you. Fully declared when we opened this session, Mr. Aronowitz, and declared every time I've spoken to it. But I do represent a broader group, all the co-ops across the state, with this vote. Thank you.
Thank you. Anything else from Mr. Aronowitz? Thank you, sir. Let's get the next online.
Hello.
Hi. Introduce yourself, sir.
You bet. Mr. Chairman, my name is Phil Irwin. I am the President and CEO of Federated Rural Electric Insurance Exchange. Federated is owned by the distribution co-ops across the United States. In fact, we write 95% of those co-ops. And in Wyoming, we write 100% of the distribution cooperatives in the state. One thing you have to understand about Federated and the co-ops in general is we all have a big focus on safety, whether it's the lineman's safety or safety of the communities that we all live and work in. I'm going to talk a little bit about the market from the insurance side, what we're seeing. First, I'll give you a little definition of what reinsurance is. It's basically insurance that the insurance companies buy for the really large losses. The affordability of the market and availability has been shrinking, the price going up. If you look in 2022, we were able to provide $62 million of coverage if a cooperative was doing the right things and the right safety measures were in place. Today, the most we can do is $42 million because of the reinsurers cutting back on this risk. We've seen some pretty substantial increases in prices over that time frame. The lower layers, the first 20 million is up about 25%. But if you go above the 22 million, it's up anywhere from 65 to 140% is what we've seen in increases. Lately, we have had some co-ops want to get quotes, and we've been out into the marketplace. And what we've seen there is basically what used to cost $2,000 or $3,000 per million had climbed to $11,000 per million. And last month, I just saw one came in at $23,000 per million. The reinsurers are charging more and more as we go. And while affordability is very important to the co-ops and their financial well-being, availability is probably the bigger concern that's out there. I told you earlier we had 95% of the market. A year ago, we had 91% of the market. And we've been picking up more cooperatives across the country because the carrier that was serving them had to exclude wildfire liability out of all their policies and therefore decided to pull out of the market. Our reinsurers are watching what is going on in the western half of the United States with a lot of these bills that are out there. And I have no doubt that it will impact their decisions going forward. To me, prevention is the key. We've been working with our co-ops to try to prevent these for years, if not decades. And so in summary, I guess the comment I would have is the co-ops are not looking for 100% immunity, but they are asking for some protection if they're doing the right things and spending money all to protect their communities and their members. And so with that, I'd be happy to answer any questions you might have.
Thank you very much. Any questions? I think we're good, sir.
All right, thank you.
Committee, I think we've heard the testimony. What is your pleasure?
Move the bill.
Motion by Landon. Discussion on the bill.
Mr. Chairman.
Senator Dockstader.
Mr. Chairman, I hesitate on the amendments with the exception of the landowners group. There seemed to be favorable response for that. So as we move through the bill, insert those, or we can insert them as a whole.
Great, but let's have a little discussion. The first, we're talking about the one from the Bud Phelan Law Office, everybody. The first one overlaps the same one that Charter Communications had presented. And so let's take a look at that. And it goes to page 11, lines 12 to 14.
Mr. Chairman, as we look at those two, I think the difference is that there's more specificity on the one suggested by Charter. Let me back up and say that differently. The one from the Bud Phelan office that we're looking at, nothing in this act shall be construed to impair, alter, or preempt terms of agreements in grants of easements. Now, the other one is, or the term of any agreements between electric utilities and third parties. It seems to be a little more broad-based.
It does, Senator, and
yeah.
I had even suggested at the time that Ms. Levin was sharing this, is that with respect to the charter amendment that says, or the term in any other agreements between electric utilities and third parties, we add for the shared use of facilities, kind of to tie it back, make sure that it's relating to the right of way and the poles and et cetera, et cetera. So let's go back to you, Senator Landon.
Mr. Chairman, I guess I would be comfortable moving the amendment from charter, whether we include that as a friendly amendment to the suggested language or not. It was testified that all the parties have agreed to this, apparently, so I think we're good with constituent groups out across. So regardless of what we do with the language, I think in principle, there's an agreement out there, so I would.
Okay, I think I follow you. Senator Dockstader, would you be agreeable if we kind of divide your proposal? Because there's 3 amendments from the Bud Phelan Law Office. Can we bundle 2 and 3 together and just dispose of them right now?
Mr. Chairman, friendly.
Okay, let's do the amendment number 2, which adds counties, and amendment number 3, which adds the no later than 5 days, and you file with these other people. Those 2 amendments are on the table. All those in favor signify by saying aye.
Aye. Just, Mr. Chairman, I'm sorry to slow it down, but.
Okay.
But the amendment 3 at the bottom, we may have to work on that language upstairs. It's not inclusive. It doesn't include our state forester. It doesn't include our, there might just be a couple of other folks who would want to include there.
I think that's fair enough, but.
So we'll catch it later.
But if we might catch them. This might do it anyway, though. Senator Landon, we'll talk more about that.
Mr. Chairman, as long
I'm
as,
an aye on the amendment. I'm
Yeah.
sorry.
Mr. Chairman, as long as we slow it up just a little bit, is 5 days adequate or 30? 30, it's, 5 days is a very quick turnaround.
I don't know, it's a plan they already have. It's filed with the Public Service Commission, so they're just resending it out to these people. It's not like they're producing a new plan. I'm getting nods on that. Okay, I'm gonna call for the question on amendment 2 and 3 of the Bud Phelan proposal. All those in favor signify by saying aye.
Aye.
And there's Representative Locke. Can we tell him that we're not gonna get to his bill? This is what the House members do. They hang around all the time. They have sad faces. We're not gonna get to you today. No, sorry. We'll take it up first thing Monday morning. All right, thank you. Okay, back to amendment number 1, which is a combination of, we're trying to combine the charter amendment with respect.
Mr. Chairman, if we want to tighten up the language, I would suggest we work off the charter suggestion, knowing that that's kind of an agreement that's been made among our parties out there.
Okay,
But you bring up a good suggestion that I think we ought to consider.
Senator Dockstader, we divided that amendment before. Can we just drop it for now? Okay, back to you, Senator Landon.
I guess I would just move the charter amendment.
Okay. Would you be okay if we added, and I think this helps the landowners too, or the term and any other agreements between electric utilities and third parties? That's not a landowner. That third party is somebody else, right? Yeah. Okay. How about for the shared use of facilities? Is that okay? Yeah, you sure can. Mr. Nicholas.
Thank you, Chairman. The only request we would have is we wouldn't want it to be original grants of easements. We want it to be grants of easements. So take our amendment had original stricken. We would ask that original stay stricken.
Do you see what he's saying?
Hmm?
You look.
Yeah.
It just doesn't muddy the waters. I don't know what original grant of easement is versus just a grant of easement, so.
How does Charter feel about striking original? Okay, I think we got something here, Senator Landon. If we could, if I heard your amendment right, it says, or the term, after easements, we're gonna remove original and remove made before July 1, 2025, and say, or the term in any other agreements between electric utilities and third parties for the shared use of facilities. Everybody, I got thumbs up. Charter, utilities. I know that's exactly what you wanted to say.
That's where we were going.
Okay.
Mr. Chairman, can I clarify?
Yep.
So I just want to make sure, so the amendment is on page 11, line 14, to delete the word original.
Correct.
So- And delete made before July 1st, 2025.
Correct.
And insert Ms. Levine's language with your language, so it would read, except for I think also that Ms. Levine also wanted where it says term in her amendment, I believe she meant terms.
Can we do that, plural? You got it.
Okay, so it would read, nothing, on page 12, it would, or sorry, line 12, it would start, section 2, nothing in this act shall be construed to impair, alter, or preempt any terms or agreements in grants of easements or the terms in any other agreements between electric utilities and third parties for the shared use of facilities.
Got it. That's exactly what Senator Landon said. All right, discussion. All those in favor signify by saying aye.
Aye.
All right, back on the bill. Anything else on the bill? Does anyone want to offer the amendments proposed by the insured associations? Any one of them or anything? I think it was mentioned that people could live with the first one. Why don't we start there? Can somebody offer amendment number 1? I got heads going in all directions out there. I'm not getting an amendment. I'm not going to offer it. I'm the chairman. Anything else from the proposed by Ms. Stewart? That's what anything else? Okay, I'm not hearing anything on that. Can we go through the bill real quick? Page 1, page 2, 3. 4, 5, 7, 8. Page 9, would anybody offer to remove section B from the bill? That's the 90-day limitation. Anybody offer to do that? Not getting a motion on that. Page 10. I have a question about page 10 I'd like to discuss. It's in this Romanet I. And it talks about, of course, we're under C on line 17, page 9. A plaintiff may recover economic loss from the electric utility as a result of blah, blah, blah. Ponderance of the evidence, the electric utility failed to substantially comply with the approved wildfire mitigation plan, and that the failure was the actual and proximate cause of the damage to the plaintiff. For purpose of this paragraph, an electric utility shall be deemed to have substantially complied if the electric utility attempted in good faith to comply with the plan, but was denied or unreasonably delayed access to a right-of-way after the electric utility requested access to the right-of-way to perform vegetation management or fire mitigation work in accordance with this plan. That sounds like a pretty big loophole to me, and I'd like more discussion about it. Because we could have, these are all our landowners out here, they all have places. Mr. AC, he's the tough guy out there, and he's denied us access to his property. And the wildfire maybe started on Mr. AC's property and went on to all your properties, okay? So are you guys foreclosed from recovery because of Mr. AC's actions? Is that what this says? I love this head nodding thing that we have that you can't see online. And so is that what we really want? Now you guys all go after Mr. AC? Is that what's gonna happen? Everybody's nodding again. So what do you all think of this? Senator Landon?
Well, Mr. Chairman, it goes to the heart of the bill. And honestly, I'm not sure, and I'm probably understanding that we don't have all of the insurance piece correct. But that's really not, in my mind, the focus of the bill. And so you bring up a very good point. That's the piece of everything that I don't fully comprehend, you know.
Yeah,
I don't know what you do about that.
okay. I see no amendments in that area. All right, anything else on the bill?
Just, Mr. Chairman, just one more thing. I think.
Yes, sir.
I think there has been a lot of work gone into this. The former chairman of Minerals has put some effort in on this and all the working group. I think it maybe is a lot like legislation that we passed down here. It's a step in the right direction. I think we've got a lot more work to do on the other side that I just alluded to. I hope that we've taken care of our landowners here. You know, I think we step forward. This wildfire thing is a big, big deal in the western United States. And we felt it firsthand in Wyoming. And so I think this is a step we can take, a lot more to do on this front.
So, thank you, Senator Lannon. I mean, one other possibility we could do is we could change the effective date. Realizes it is a crisis in the world, but you could push the effective date off past another legislative session and let this percolate a bit. Could do that. Not hearing from anybody they want to do that. Okay. Anybody else want to say anything before we call the roll? Let's just call the roll.
Mr. Chairman, I'm calling the roll on House Bill number 192, and I'm going to double check or triple check one time. That's with 3 amendments. Am I correct?
Correct. The 2 amendments from
the Bud Fallon Law Offices, and then the one from,
a combination with the Charter Communications. Yes.
okay. So with that, this is the roll call vote on House Bill number 192, Public Utilities, Wildfire Mitigation and Liability Limits, with amendments. Senator Boner.
Aye.
Senator Dockstetter.
Aye.
Senator Landon.
Aye.
Senator Steinmetz.
Excused.
Chairman Case.
Ah,
That was an aye.
I was an aye.
So we have 4 ayes and 1 excused.
Thank you very much. Sorry we didn't get farther today. We'll endeavor to start at 7:30 on Monday. And we